Good afternoon, everyone, and welcome to our Standing Committee on Justice and Human Rights as we begin our study of the Maine estimates. I could read the entire agenda, but I think everyone here is perfectly capable of reading all that we're studying. It's a great pleasure to welcome our Minister of Justice and Attorney General of Canada, the Honourable Jody Wilson-Raybould. And she is joined by various officials from the Department of Justice. She's joined by Carole Morency, who's the Director General and Senior General Counsel, Criminal Law Policy Section, Policy Sector. Welcome. By Nathalie G. Drouin, Deputy Minister of Justice and Deputy Attorney General of Canada. Welcome. And Joanne Bernard, Assistant Deputy Minister, Management Sector and Chief Financial Officer. Welcome. The Minister is with us until 4:30, after which officials will be open to answering questions. So we'll try to get through as many questions as we can before then. And I will turn it over to the Honourable Minister to begin her comments.
Perfect. Well, thank you. Thank you, Mr. Chair, and thank you, as usual, to the members of the committee. And I certainly appreciate the opportunity to be here before you to give some brief remarks and then look to answer some questions. As you indicated, I'm joined by Nathalie Drouin, Deputy Minister and Deputy Attorney General of Canada, Joanne Bernard, Assistant Deputy Minister of Management and Chief Financial Officer Sector, Carole Morency, and joining us in the room as well is Francois Daigle, Associate Deputy Minister, Elizabeth Hendy, Director General of the Programs Branch. I'm also joined in the room by representatives of a number of the independent agencies and organizations that fall within my portfolio. I would like to discuss how the Department of Justice intends to use the funds granted through the 2018-19 Maine estimates to promote and maintain a fair, transparent, and accessible justice system while providing high-quality legal services to the federal government. These include a wide range of legal advisory, litigation, and legislative services to government departments and agencies. The Department of Justice has a total budgetary authority of $697.75 million through 2018-19 Maine estimates, an increase of $42 million from the previous fiscal year. This additional funding is for major priorities, including federal support to the family justice system, immigration and refugee, legal aid, and the Indigenous Justice Program, among others. Much of this year's authority will support the stewardship of the Canadian legal framework by directing funding to the provinces and territories with whom we share responsibility to administer justice. The funding will help maintain and support a bilingual and bijural national legal framework. Funding through the Maine estimates will also support the Department's ability to transform and modernize the justice system in keeping with the values of Canadians while protecting and maintaining the rights enshrined in the Constitution and in the Charter of Rights and Freedoms. Our review of the criminal justice system is ongoing. It is intended to ensure that our criminal laws protect Canadians, hold offenders to account, meet the highest standards of fairness and equity, respect the Charter, and demonstrate the utmost compassion to victims. These efforts will help strengthen public confidence in the justice system and judicial institutions. Our review, along with results of other consultations and government priorities, is already informing initiatives and reforms that we are introducing to modernize the criminal justice system. In March, I introduced Bill C-75 to help reduce court delays and to address the overrepresentation of Indigenous peoples and vulnerable populations as both victims and accused in the criminal justice system. We anticipate that the bill will come to this committee shortly. In C-75, we are proposing amendments to the bail regime and to how breaches of administration of justice offences are handled. In particular, these changes will help eliminate the unnecessary detention of individuals pending trial, will help eliminate unnecessary bail conditions, and will ensure that fewer people are needlessly charged and convicted of minor administrative offences that do not impact public safety. These measures will have a particular positive impact on Indigenous and marginalized Canadians who are disproportionately represented in our remand population and who are disproportionately charged and convicted of administration of justice offences. We are encouraging the selection of juries that better reflect the diversity of our communities, and we are bringing in stronger measures to address the problem of intimate partner violence. We are also proposing measures that will avoid re-traumatizing victims by reducing the number of inquiries and issues for which they have to testify. In addition, Bill C-75 will reclassify many offences in the criminal code in order to give our prosecutors the discretion they need to choose the most efficient and appropriate procedure. Our government has also launched measures to better support Indigenous people and vulnerable persons as they navigate the criminal justice system. We continue to fund the Indigenous Court Work Program with $9.5 million annually. Integrating Indigenous culture, language, and traditions, these court workers provide direct services before, during, and after court. They also provide courts with crucial information to guide sentencing and bail decisions, while connecting victims, witnesses, and family members to culturally safe assistance. In 2016-2017, over 75,000 Indigenous men, women, and young people in over 435 communities received these services. We have stabilized funding to the Indigenous Justice Program with over $11 million per year ongoing to increase the use of restorative justice and reduce the rate of Indigenous incarceration. In 2015-2016, we have continually increased our funding to the Department's Legal Aid Program to fund provincial and territorial criminal legal aid programs. This helps economically disadvantaged persons at risk of incarceration and youth facing prosecution under the Youth Criminal Justice Act. The Department's Youth Justice Fund supports projects with alternatives to incarceration and encourages a more effective youth justice system. That includes just over $6.5 million towards 16 multi-year projects that focus on culturally relevant programming for Indigenous youth in the criminal justice system. We have also increased funding to immigration and refugee legal aid by over $14 million, with an additional $3 million in contribution funding for legal aid systems and access to justice services. Mr. Chair, our government is committed to ensuring that victims of sexual assault and gender-based violence are treated with the utmost respect and dignity. The Department of Justice Victims Fund provides $27.4 million in grants and contributions supporting 476 projects across Canada. This funding supports research, innovative pilot projects, and frontline services for victims and survivors of crime across Canada. In 2017-18, more than 100 victims of human trafficking received case management and related services, and more than 450 women and girls at risk received information about services and assistance. In Budget 2017, our government introduced its gender-based violence strategy and over $100 million over 5 years. Budget 2018 contributed an additional $86 million over 5 years and $20 million annually thereafter to expand on the strategy, with my department as a key contributor. In Budget 2018, Budget 2018 proposed $50.4 million over 5 years to address sexual harassment in the workplace, $25.4 million for boosting legal support funding across the country to support legal action by victims, and $25 million for outreach. We have continued our efforts to promote and maintain a more diverse judiciary. Since 2015, I have made 179 appointments and elevations. Of these appointees, over half are women, 8 are Indigenous, and 15 are visible minorities, 11 identified as LGBTQ2, and 3 are persons with a disability. We continue to fund the necessary training for a more culturally sensitive and responsive bench as well. And finally, Mr. Chair, last month I introduced Bill C-78, the first changes to the Divorce Act in more than 20 years. The proposed reforms will ensure that our family law system is focused on the best interest of the child, better supports the safety and well-being of individuals and families, and is more efficient. Our commitment to improving family justice includes Budget 2018 funding of $77.2 million over 4 years and a further $20.8 million ongoing to expand the unified family courts across the country. This measure will create 39 new judicial positions across a number of provinces while enhancing access to justice and improving outcomes for families and individuals. Again, Mr. Speaker, I would certainly like to thank the members of this committee for your ongoing work and look forward to our discussions today. Thank you.
Thank you very much, Minister Wilson-Raybould. So again, colleagues, the Minister is with us till 4:30. If we keep to our times, we should get 2 rounds of questions in. So we're going to start with Mr. Nicholson.
Thank you very much, and thank you, Minister. Your last comment there was one of the first things I was going to ask with respect to the Unified Family Court. Have you had any uptake or feedback from the provinces with respect to this? Generally, this would, of course, have to be a consolidation of the courts in a particular area. What have you heard from so far?
Well, I appreciate the question, and certainly, again, we were very pleased in Budget 2018 to have the ability to expand unified family courts. We have, leading up to Budget 2018, and by virtue of the fact that it was in my mandate letter from the Prime Minister, have been engaged on an ongoing basis with the provinces and territories, and are pleased to say that there has been substantial feedback from the provinces, in particular with respect to the province of Alberta, the province of Ontario, and Nova Scotia, and Newfoundland and Labrador, all of whom are more than anxious and pleased to participate in the Unified Family Courts.
Thank you very much. I'm sure it will be well received. You talked about C-75, the bill, and one of the things you were quoted as saying that hybridizing these offences will not make them less serious or should be subjected to lower sentences. You may have heard today in question period, your colleague Ralph Goodale said that with respect to impaired driving, that your government, and indeed our government, has the toughest laws, I think he said, in the world. He said in terms of that. Don't you think that hybridizing this, and so somebody who's convicted of impaired driving causing bodily harm will now have the option under C-75 of having that as a summary conviction offense, and with a penalty, I believe it's 18 months or even a fine. Do you not think that that is actually lessening the penalties with respect to impaired driving causing bodily harm?
Well, thank you to my colleague for the couple of questions. I did have the opportunity, I did hear the Minister of Public Safety speak in the House today, and I believe what he was referencing is with the passage of C-46, we will have be among the toughest impaired driving laws throughout the world. I'm very hopeful that this bill is going to proceed through the other place. In terms of the hybridization of offences, and we've had the opportunity to have these discussions in a number of different forums, what we are doing with respect to the hybridization of offences is to give prosecutors the necessary discretion, as the member knows very well, to proceed by way of summary or indictment. And this does not in any way touch on the sentencing, the fundamental principles of sentencing. This is, again, to provide the discretion to prosecutors to proceed in either fashion, recognizing that proceeding by way of summary offences where the situation merits is and will contribute towards the quicker processing or moving through the courts to, one, address delays in the comprehensive package that we put in place with respect to C-75. I will say that with respect to the impaired driving offence that the member, or that Mr. Nicholson raises, this was something, the hybridization of that particular offence was something that was contained within C-226 by his colleague Stephen Blaney. This was something that was in that particular piece of legislation, as was what I'm very proud of that is contained within the C-46 mandatory alcohol screening.
That being said, I mean, you said that with the passage of C-46 that we'll have the toughest sentencing regime with respect to impaired driving. You don't think there's anything inconsistent with the possibility that part of the penalty could be a summary conviction? And I mean, in terms of the toughest sentences, in the world, I mean, I'd be very interested, and we'll have, I'm sure, a lot of witnesses come forward. I'd be fascinated to hear if this is the case in any other jurisdiction. Do you know of any other jurisdiction that, particularly in the common law, that you could be convicted of impaired driving, causing bodily harm, and that you might be subject to a penalty as low as a fine?
Well, thank you for the question, and I just was looking over at Carol Morency. I do not know at this point in other jurisdictions. I'm happy to see and answer that question for the member afterwards. But in terms of the hybridization and how a prosecutor would proceed, it would be based on the facts of each individual case and what would be necessary and appropriate given the gravity of the offense. We'll follow up in terms of the answer, but we certainly will, in continuing to work with the provinces and territories and continuing our overarching review of the criminal justice system, ensure that the reform measures that are contained within Bill C-75 will be monitored, will be further considered as we continue to work in a collaborative fashion with other jurisdictions.
We're just going into the summer break, as you know, and I remember the last summer break that one of the sections in the bill that was introduced into Parliament was removing of 176, the section that protect religious services and members of the clergy. And while there was some discussion just before the break, one of the things that I heard from colleagues and others is that a huge number of emails and contacts were made with members of the government and with the Department of Justice. Are you starting to hear any pushback already yet on the impaired driving section and the hybridization of that particular offense? Are you starting to hear that, or is that something we might probably hear over the course of the summer?
In terms of the impaired driving offenses?
Yes. Are you hearing yet? Are you getting some pushback on this, or lots of inquiries?
I can't think of a specific pushback that we've been getting, but we do, as you know, receive a substantial amount of correspondence in our office, but we'll continue to follow all the feedback around this and the concerns. This is something that we have received very public support from through Mothers Against Drunk Driving.
They're supportive of the hybridization of this section?
Yes, they're supportive of the contents of Bill C-46 and the various provisions contained within there.
C-75, have they taken a position on that?
On C-75, in terms of the hybridization of offenses, I don't believe that we've heard specific feedback from that. Maybe I can look to Carol.
Maybe just to clarify, Bill C-46 proposes to hybridize what is currently a straight indictable offense of impaired causing bodily harm. C-75 proposes a consequential amendment because C-75 is proposing to hybridize a number of offenses.
That's right.
And in doing so, it's using a particular approach and wording. So the only consequential relationship between C-75 and C-46 is that the wording that's adopted or proposed to be adopted as part of the broader package in C-75 would be reflected in the impaired driving causing bodily harm hybridization as well.
Out of time on that one. We're at 8.
Okay.
Mr. McKinnon?
Thank you, Chair. And thank you, Minister and officials, for being here once again before us. My question is for the Minister, of course. The 2018-2019 departmental plan notes that the department will be advancing work in various priority areas, including HIV non-disclosure. Can you provide the committee with details about this departmental priority?
Sure. Well, thank you for the question. This is a public health issue. around HIV non-disclosure, we are working very diligently with our partners within Health Canada, within the Public Health Agency of Canada, with provinces and territories to do as much as we can to reduce the stigma, to reduce discrimination, and to that end, we were very pleased on World AIDS Day last year to release a report that we had compiled that engaged many stakeholders, many different jurisdictions about how we can proceed to address this particular issue and not to criminalize, but to make decisions, or overly criminalize HIV non-disclosure, but make decisions based on evidence. We've received a substantial amount of feedback, as I said, contained within the report, and we are going to continue to ensure that we work with stakeholders, continue to work with the provinces and territories about how we can proceed in terms of perhaps looking at guidelines for prosecutors. I know that the provinces of Ontario has taken steps in this regard, and we applaud them for their work. But just to underscore that this is an important issue that we are continuing to work on, and we'll continue to work on with our colleagues in the provinces and territories.
Thank you. Amendments, do you think this will require amendments to legislation? And if so, when might such legislation be brought before the House?
In terms of the HIV non-disclosure, well, I mean, there are options. What we have done was release the report last year that speaks to the potential of working with our counterparts to release guidelines to prosecutors. There is no determination, or a decision hasn't been made on how we can proceed. As I said, the province of Ontario has made some steps. We're certainly continuing to look at this and work again with Health Canada and others to proceed to take an approach to HIV non-disclosure that doesn't overly criminalize individuals, but takes a public health approach to ensure that we are reducing the stigma around HIV and tackling it in terms of what they call the 90-90-90 approach.
Thank you. Bit of a change of pace. We'll move to court challenges. So as you may recall, we as a committee did a study on court challenges, on the court challenges program, and made recommendations. The 2018-19 departmental plan again notes that the Department of Justice will support the Department of Canadian Heritage to restore a modern court challenges program to enable Canadians to bring before the courts cases of national significance related to constitutional and quasi-constitutional matters. And in September 2017, the government announced that the University of Ottawa had been selected to implement and administer the new program. And according to the Department of Canadian Heritage, decisions regarding CCP funding will be rendered by two independent expert panels, an official language rights expert panel and a human rights expert panel. And the members of the panels are to be identified through a transparent process. Have the members of the expert panels been identified at this point?
Well, thank you for the question, and you have described the status of the Court Challenges program. Of course, I, in support of the Minister of Canadian Heritage, was incredibly pleased on February the 7th of last year to reinstate the Court Challenges program. As far as I understand, and this would be a question for the Minister of Canadian Heritage, I do not believe those individuals have been identified. What I do know is that work is ongoing to move to be able to identify those individuals and ensure that the Court Challenges program is up and running as soon as possible.
Well, that kind of leads me to my next question is, how are you supporting the Department of Canadian Heritage to implement this, and when might we expect the renewed Court Challenges program to be operational?
Well, again, my officials and the Minister of Canadian Heritage and myself have ongoing conversations. We had conversations leading up to the announcement of the reinstatement of the Court Challenges program in and around official languages and around human rights. We had conversations in terms of the expansion of the program to address other charter rights. I wish I could give you a definitive answer as to when the Court Challenges program will be up and running, but I know that it is the determination of the minister to put that in place as soon as possible.
Thank you, Minister.
Very much. Mr. Rankin.
Thank you, and thank you, Minister, and to your officials as well for being with us today. It won't surprise you, Minister, that I'm going to ask about something that has been called the elephant in the room in your criminal justice reform, namely the failure to address mandatory minimum penalties. As you know, call to action number 32 in the Truth and Reconciliation Commission report called on you to amend the criminal code to allow trial judges, upon giving reasons, to depart from mandatory minimum sentences and restrictions on the use of conditional sentences. It pointed out that that would assist in particularly addressing the specific needs of Indigenous offenders. Indeed, to my astonishment, the correctional investigator of Canada last year stated that although the First Nation population of Canada is about 5%, over 1/4 of prisoners are Indigenous, and in respect of Indigenous women, over 1/3 of our incarcerated Canadians are Indigenous, and it was suggested that to address mandatory minimums would have a very positive effect on what I call the crisis of overrepresentation. So today I had a press conference with my colleague, Member of Parliament Sherry Benson, who tabled Private Member's Bill C-407, similar, by the way, to Senator Kim Pate's recently tabled Bill S-251. I should add that that bill was prompted by high school students from Saskatoon who chose this important measure as their primary suggested change in Canadian law. And in the audience today, I recognize Brody Boker and Camilo Silva, who drafted that bill, helped in drafting that important measure. Lastly, Minister, it was reported that over 2/3 of all charter challenges in the courts, 256 charter challenges that were in the courts are mandatory minimum sentence challenges. Imagine how much time and money that's taking to address that issue alone. Now, Minister, you came to office and almost 2 years ago, you promised in a Globe and Mail article in November that, quote, new legislation on mandatory minimums is coming soon, certainly in the early part of next year, close quote. That was early part of last year. So my question to you is, will you be moving forward in a timely way with your commitment to address this crisis in over-incarceration of Indigenous Canadians by way of fixing the mandatory minimums? And will you commit today to adopt the bills that I referenced earlier, Private Member's Bill C-407, Senate Bill S-251, or perhaps include them in C-75 so we can address this important issue?
Well, thank you for all of the questions and the comments. And I would start, Mr. Chair, and to my colleague, by recognizing that I agree with you that there is a crisis in terms of overrepresentation of Indigenous peoples and other marginalized Canadians in the criminal justice system, and we need to do all we can to ensure that we address that overrepresentation. As the member knows, we've taken many steps. The introduction of Bill C-75 was one of those steps in terms of how we approach administration of justice offences, how we look at bail reform, and having regard to Indigenous peoples in terms of bail and administration of justice. But I hear the question that has been asked in terms of mandatory minimum penalties, and I would first of all say that I applaud Brody and others in the audience for getting involved and engaged in discussions around how we can improve the criminal justice system. With respect to mandatory minimum penalties, I am continuing to ensure that we look at sentencing and sentencing reform. Mandatory minimum penalties is not within Bill C-75. I wanted to proceed as expeditiously as possible to ensure that I introduced a bill that would tackle the delays in the criminal justice system. That's not to say that looking at that sentencing reform, including mandatory minimum penalties, is not important, because it absolutely is. And as the member said, I've been very clear in terms of where I am at and my views with respect to mandatory minimum penalties. My views that judges certainly should be provided the necessary discretion to impose sentences appropriate to the offender in front of them. Having said that, we need to ensure that we are going to be putting in place sentencing reform that will stand the test of time. As the member has indicated, mandatory minimum penalties are being litigated quite extensively. There are cases wherein the Supreme Court has upheld a mandatory minimum penalty, and there are cases where they have not. I want to ensure that I've taken all possible steps and diligence as we continue to be focused on our commitment around sentencing reform, and to do it in a manner, as I said, that will stand the test of time. And with respect to the two private, the private members bill and the public members bill, I have had ongoing conversations with Senator Pate. I would welcome conversations with your colleague Sherry. These are considerations when those bills come before me that I will engage in discussions with my colleagues on.
Just as a follow-up then, you point out, I think, that some provinces, Court of Appeal have upheld, and some courts of appeal have not upheld mandatory minimums, creating essentially a patchwork system across our country for a law which is federal in nature, something that is really quite disturbing to a lot of lawyers who practice criminal law, that we would have such a patchwork develop. Isn't that yet another reason to move with expedition, as you said you would, so that we would have had, I thought you said, in 2017, reform efforts? Now we have private members' bills, Senate bills. We have a 300-page bill that doesn't even mention it. Isn't it important that we grapple with this in a more timely way, given the patchwork that's developed, as you indicated?
Well, again, in terms of sentencing reform, this is something that we are going to continue to review. This is a priority, as you say. It's in my mandate letter. I will consider the public and the private members' bills when they come before me and have discussions. And further, I would encourage this committee to, when Bill C-75 comes here, I would be very happy to continue to have this discussion around sentencing reform and hear what, if anything, the honourable members of this committee have to say with respect to what's in C-75 and perhaps what's not in C-75.
Mr. Fraser.
Thank you. Thanks very much, Mr. Chair. Minister, thank you for coming to our committee, as always. Good to see you. And thank you to your officials as well for being here today to answer our questions. I want to start with something you've touched on already. That is that Budget 2018 put forward funding to implement the unified family courts in the provinces that don't already have that. I'm from Nova Scotia and was a practicing lawyer there in the family system, and can tell you that this is going to be well received in Nova Scotia, and I'm sure in the other provinces that this is going to be affecting. I know it will be standardizing, rather than having two levels of court for family jurisdictions in those provinces, and this is going to be make a big difference for family law in those jurisdictions. I'm wondering if you can touch on why it's so important that the unified family court system in Canada is standardized across these provinces that don't already have it, and what it will mean for family law justice in Canada.
Well, thank you for the comments and the questions, and again, we were very pleased to see the support for unified family courts in Budget 2018. We're working towards ensuring that we can meet the needs and identify the judges that were in Budget, the 39 judicial appointments that were in the budget in the 4 provinces that expressed a very real desire to expand their programs or to actually set up programs. As I said earlier, in Alberta, in Ontario, in Nova Scotia, and in Newfoundland and Labrador. In terms of family law and access to justice in family law, the unified family courts, as you know, having practiced in Nova Scotia, will create a space where individuals can go, and will have within those courts, the Unified Family Courts, the ability of the so-called one-stop shop. We'll have specialized judges in family law in those courts. We'll have simplified procedures within those courts, and also have community programs and support services to assist individuals that are going through, which for most people is the only time that they interact with the justice system is in family law. And we wanted to ensure that we do everything that we can to assist those individuals in gaining the necessary access to justice in a timely way and as efficiently and cost effectively as possible. And when we were going through all of our discussions and consultations with the provinces and with individuals, there was clearly a desire to ensure that in concert with the Unified Family Courts that we're taking the necessary steps in terms of the reforms that we've proposed in Bill C-78 around the Divorce Act and around two other pieces of federal legislation to also contribute to improving the family law situation in the country.
Thank you, Minister. And I agree with you that in implementing the Unified Family Courts, along with the implementation of the bill currently before Parliament, C-78, this is going to have a big effect on the efficiencies in the family law system in Canada. And Bill C-78 is the first time in over 20 years that there's been a major overhaul and update in our divorce laws, and that is going to really help a lot of families in Canada who are going through those challenging circumstances. I want to turn now to C-46, which was touched upon earlier, and the provision in C-46 dealing with mandatory alcohol screening. Our committee studied C-46, and one of the things that was stated over and over again before our committee was that to reduce the incidence of impaired driving, there needs to be a fear of getting caught. That is really what is going to be important in reducing the incidence of people being impaired on our roads. And mandatory alcohol screening in other jurisdictions, we've heard, has worked. I know there has been some discussion about whether it's constitutional, but there's constitutional experts who have weighed in that believe the provision is justified under the Charter. And the main reason for that is that it is a compelling public interest to reduce the harm of impaired driving on our roads. So I know this bill is currently in the other place. It's before the Senate right now. The House of Commons has already passed that. What do you say about the importance of getting Bill C-46 passed by both houses of Parliament and into law, along with the provision of mandatory alcohol screening to reduce the incidence of drinking and driving on our roads and impaired driving overall?
Well, thank you for the comments and for the question. And you reiterated quite well in terms of other jurisdictions and the Charter implications with respect to mandatory alcohol screening. On Bill C-46, mandatory alcohol screening is the center of our proposed renovation of the impaired driving laws in Canada. As you've said, in other jurisdictions that have mandatory alcohol screening, those that would have gone undetected going through a road stop, for example, are in the range of about 50%. So the idea of having mandatory alcohol screening as a reality would be a significant deterrence in terms of those individuals who think it's appropriate to get behind the wheel of their car when they have been drinking alcohol or impaired by drugs. The objective with respect to mandatory alcohol screening is to ensure that individuals do not do that, do not get behind the wheel while impaired by any kind of alcohol or drug. And I was very disappointed when the senators voted to remove mandatory alcohol screening. This is, again, a hallmark of Bill C-46, and we are determined to have mandatory alcohol screening contained within this legislation as it proceeds, because it will save lives. Canada has backed mandatory alcohol screening, and 40-some jurisdictions throughout the world have proven, based on evidence, that this saves lives. This saves lives, and what could be more important than that?
Thank you, Minister.
Thank you so much. So I just again remind everyone the minister needs to leave at 4:30, so any questions after that time will be answered by officials. So we're going to try to get through as many as we can in our second round before the minister has to leave. But that's so try to be quicker with your questions if you can. But it's great to hear the fulsome questions and answers. Mr. Astasi, you're first in the second round.
Thank you, Mr. Chair. Madam Minister, allow me to join my colleagues in welcoming you to this committee once again, and also thank all your officials for being here. I'd like to follow up with the approach taken by Mr. Fraser, just to ask about some of the changes that we're seeing. And the first question I had was in relation to Bill 74, which has to do with having new positions appointed for Ontario, Saskatchewan, and the federal court. Now, Bill 74 is still before the House, but as I understand it under this bill, there will be an additional complement of 6 positions for the Ontario Superior Court. There will be 1 addition to the Saskatchewan Court of Appeal and 1 addition to the federal court. I can tell you that this has been received very positively in the legal community. So just to ask you 2 quick questions. First of all, what is, how did you arrive at these new numbers? And secondly, as a follow-up, how do you suspect this will improve the efficiency of our judicial system?
Well, thank you for the questions, and indeed you're quite right in terms of the support for new judicial positions in jurisdictions that you referenced. How did we arrive at those numbers? Myself, my Judicial Affairs Advisor, and my office have ongoing conversations with all jurisdictions, my counterparts in the provinces and territories, as well as discussions with the Chief Justices in the provinces. And working with, and my officials working with jurisdictions, assess through ongoing conversations around building a business case for additional positions. We have arrived at what was reflected in terms of our ask with respect to budget 2018. And the second question was, how is this going to improve efficiencies? Well, we want to ensure that we have the necessary judicial resources in place, necessary judicial resources that reflect the diversity of the country. And in addition to these appointments, we are continuing to proceed with our renovated judicial appointments process, of which I said in my opening remarks I was pleased to have appointed 179 judges to the superior courts. We're going to continue to fill these vacancies, continue to work as we are on an ongoing basis with the Chief Justices, with the judicial advisory committees that review judicial applications to proceed as quickly as we can to fill the necessary judicial vacancies with meritorious candidates that reflect the diversity of the country.
Thank you. And the follow-up question was if I could now switch to Bill C-16, which received royal assent in June of last year. Under that particular bill, the grounds for discrimination in the Canadian Human Rights Act has been broadened, namely by adding a gender expression and gender identity as well. So would you mind explaining to us what you think the impact of these changes will be on the Commission? And is this in any way responsible for the increase in the number of complaints that have been received by the Commission?
Well, I appreciate the question, and I will say from the outset, I know that Marie-Claude Landry, the Commissioner, would have the ability to answer that question specifically. But just with respect to Bill C-16, which was the gender identity, gender expression, adding those as a prohibited ground in the Canadian Human Rights Act, as well as amending the Criminal Code, was an extraordinary process and bill to move through Parliament. Led legislation that was advocated for years by so many people that may express themselves differently in terms of their gender. And it was an incredibly proud moment for me, and I know many Canadians across the country feeling that there is recourse in terms of discrimination based on gender identity and expression. In terms of the Canadian Human Rights Commission, they have, I know, been engaged in information gathering in terms of providing educational materials on gender identity, gender expression, and recognize that there will be an increase in terms of the cases that are before the Canadian Human Rights Commission, and I would say in terms of numbers and in terms of the substantive information and educational exercises and engagements they've been having across the country, that the Commissioner would probably be better placed to speak to her important work.
Thank you, Minister.
Thank you very much. Mr. Cooper.
Thank you, Mr. Chair. Thank you to the officials, and thank you, Madam Minister, for being here. I want to, first of all, just follow up on an answer that you provided in response to a question posed by Mr. Nicholson, and this deals with the hybridization of offenses. You indicated that there really is no problem because all it is doing is giving prosecutors discretion to prosecute by way of summary conviction when, as you put it, the circumstances warrant. That's true. Prosecutors would have the discretion through the hybridization. So I would ask, when would circumstances warrant going by way of summary conviction for, I don't know, arson for fraudulent purpose, for example?
Well, thank you for the question. And in terms of individual cases, individual charges, how a prosecutor decides to proceed by way of summary conviction or by way of indictment would be in their discretion. What we're wanting to do is to provide additional tools based on the individual facts of a particular case, and I'm not going to hypothesize or create a particular case, but to provide prosecutors with the additional tools to exercise their discretion in that regard. The objective with respect to the hybridization or the reclassification of offenses is to assist in addressing delays, not necessarily in and of themselves, but broadly speaking in terms of what we have proposed in terms of the bold reforms in Bill C-75.
Yeah, thank you, Minister, for that. And I have to say, I think a lot of Canadians would be very surprised that there, and couldn't think of any circumstances that, whether it be for arson for fraudulent purposes or participating in a terrorist organization or kidnapping a minor or advocating genocide or perhaps material benefit from sexual services, but any of those offenses and a whole list of others are suitable to be prosecuted by way of summary conviction, to go from a maximum sentence of 10 years to something as low as a mere fine. I think Canadians would be astounded by that. But you also just mentioned with respect to the issue of delay that that's one of the objectives of hybridizing. We have the Jordan decision. Under Jordan, a delay is deemed presumptively unreasonable after 30 months between delaying of charges and the conclusion of a trial for matters before superior courts, 18 months for matters before provincial courts. Prosecuting by way of summary conviction is to prosecute at provincial courts. The provincial court level, which would reduce the timeline to prosecute by almost in half. So how does that deal with delay? Isn't this just a case of downloading onto the provinces?
Well, thank you for the comments and the questions, and I will tackle the last first and then move back. In terms of downloading on the provinces, I want to be very clear. We have been engaged in a broad-based review of the criminal justice system since I became the minister and the Prime Minister asked me to engage in this. And we have, through those consultations and discussions, been very actively participating in federal, provincial, and territorial meetings with my counterparts in the provinces and territories. In fact, because we share, as the member knows, the administration of justice and our responsibilities, we have come together on many occasions as ministers and as officials in working groups to propose what necessary bold reforms would be needed in order to address delays. So this is not a matter of downloading to the provinces. This is something that we have had many discussions about, proceeding by way of summary conviction for, and all offences are serious. Don't take my words or misconstrue my words. But in proceeding in provincial court, cases can proceed in a quicker fashion where the situation and the case is appropriate, and that would be determined by prosecutors. But I will say, and the member talks about Canadians being astounded, I want to be very clear that the proposals that we've put in place with respect to Bill C-75 and the hybridization of offences or the reclassification of offences does in no way, shape, or form touch on the fundamental principles of sentencing. We are not changing that. This is going to continue to be the case, and the judge is going to continue to have to assess the proportionality, the degree of responsibility of the offender, and to misrepresent that we're doing something and changing the sentencing principles
no, Madam
is a
Minister, I'm not
mischaracterization.
misrepresenting anything. I think I was quite clear that you are taking a sentence under an indictable that is punishable by up to 10 years, and if it's prosecuted by way of summary conviction, the maximum is 2 years less a day, and it could be as low as a mere fine. That's not a misrepresentation, that's a fact. But I want to also ask you about Bill C-39, which was introduced on March 8th of 2017. Lyle and Marie McCann of St. Albert were brutally murdered by Travis Vader. After waiting for justice for 6 years, the McCann family, just when they thought that justice had arrived, found out that it had not arrived because the trial judge applied an unconstitutional section of the Criminal Code, Section 230. To your credit, you did introduce Bill C-39 to repeal unconstitutional sections of the Criminal Code, but more than a year later, that bill is stuck at first reading. It has now been rolled into C-75, which is a big bill. It's, as you can see, a contentious bill. There's a lot of debate around it. By contrast, with C-39, there's no debate. I think there's a consensus or near consensus that we need to get unconstitutional sections of the Criminal Code out of the Criminal Code. And I just don't understand, after more than a year, what the delay is and why it has been rolled into C-39 when, quite frankly, this could have been passed on a voice vote a year ago.
Well, with respect to C-39, which, as you say, has been now put into C-75, as have another very important pieces of legislation around victim fine surcharge and human trafficking. In terms of the passage or proceeding in the House in the time, I'm not sure that's a question that I can specifically answer, but why we have put these pieces of, or these bills into C-75 is to ensure that the important provisions that are contained within these proposed pieces of legislation are moved through. It is and makes sense to me in terms of a thematic approach to put these pieces or these bills into C-75 because they are all looking to amend the criminal code. I hear the member in talking about the McCann family and the tragedy that the McCann family had faced, and we want to ensure in the then Bill C-39 and in Bill C-51 that we do renovate the criminal code, that we do get rid of the unconstitutional provisions. And I would look to the member as well as everybody in this honourable committee to have vigorous debates and discussion about all of the provisions and proposals that are contained within C-75. This committee and in the other House, the Legal and Constitutional Affairs Committee of the Senate, have been very diligent, and necessarily so, in terms of seeking for myself and our government to address delays in the criminal justice system. Bill C-75 does do that, as well as address the necessary changes that we've proposed in terms of the victim fine surcharge to address indigent offenders, as well as get rid of the constitutional provisions beyond 230 that the member opposite, or the member has talked about.
So I think this will be the last question the minister will be able to take herself. Afterwards, we'll be left with the other officials, but for the moment, I think that we're going to hit 4:30 at this question. Now, the next question is Ms. Khalid in terms of this round. Ms. Khalid?
Thank you, Chair, and thank you very much to the Minister and the officials for your time today and for your very important work on this very important file. Minister, something that I face in my constituency on a very regular basis are refugee cases. Some of them are very, very heart-wrenching. And we've heard, as we did our study on access to justice and access to legal aid, that the demand for immigration and refugee legal aid is going to increase rather than decrease, and that the current investments are not sufficient. According to the 2018-2019 main estimates, the Department of Justice's spending authority will increase by $14.2 million in contribution funding for the immigration and refugee legal aid. I'm wondering, how will that funding be distributed across the country? Like, what will be the split between the provinces?
Well, thank you for the question and the recognition that this is an ongoing issue and the necessity to, as always, address legal aid needs in the provinces and territories, and in this case with respect to immigration and refugee legal aid. I will say that the Department of Justice, and you've already spoken about the amounts that are contained within Budget 2018, but we continue to work with my colleague, the Minister Hussen of Immigration and Refugee and Citizenship Canada, on this. The allocations of the dollars will be provided, as you say, to the provinces and territories, and we will work in collaboration with the provinces and territories to determine what the appropriate distribution of these additional resources are, recognizing that there are different circumstances in provinces with respect to this issue.
Is there a long-term strategy for providing more support in the justice system to these asylum seekers as they settle into our country?
Well, again, I'm not certain that I'm the most appropriate person to be answering those questions, but to assure the member and members of this committee, we do work very closely with the Minister of Immigration on how we can address these really important issues and provide the necessary legal support to the Minister.
Thank you, Minister. I'm just going to change streams a little bit here. According to the 2018-2019 main estimates, there is going to be an increase in $11 million in funding for the Indigenous Justice Program, which was the Aboriginal Justice Strategy before, which provides for community-based programs that use restorative justice approaches as an alternative to the mainstream justice system and corrections. How much money will be dedicated to this program on a yearly basis?
Well, I love that question because I was incredibly happy that we now, for the Indigenous Justice Program, have ongoing and stable funding in the amount of $11.2 million. This program has reaches 197 specific programs and 750 communities across the country. It is to support community-based justice programs, to support restorative justice measures, to address issues for individuals individuals that are marginalized or suffering from addictions and mental health issues. And it is proven, the Indigenous Justice Program, to have a reduction in the recidivism of these individuals that come before the justice system. And I think the Indigenous Justice Program, which has been long up and running but now has stable funding, is an incredible step towards ensuring that we continue to take alternative or look at alternative forms, rehabilitation, restorative justice, and I hope and trust that that will continue.
Thank you, Minister. Minister, we've been studying human trafficking domestically within Canada, and we've learned that Indigenous communities are really impacted by it. Will the Indigenous Justice Program be a way of supporting those minorities that have been trafficked, that are victims or involved in that whole scheme? Will it be a resource for them to use in terms of getting that rehabilitation that they require or the support that they require as well?
I think it's an important question, and we are seeking to address human trafficking in many different ways, including within Bill C-75 and providing additional tools to prosecutors and law enforcement. But in terms of this program and assisting, there has and is opportunity to support individuals that have been impacted by human trafficking in terms of beyond the Indigenous Justice Program, looking at victim support services and our victims funds that have provided dollars to assist in this regard.
Thank you, Minister.
Thank you.
I think what I'd like to do now is thank the Minister very, very much for being here today. We really very much appreciate it. And what I'll then do is ask for a brief recess while we allow the justice officials to bring whoever else up they'd like to join them for our remaining questions. So once again, thank you very much, Minister Wilson-Raybould. Meeting briefly suspended. Est-ce que je peux demander à tout le monde de siéger?
Could I ask everyone to please take their places? We're going to continue with our meeting now. We took a very short recess, but now we're going to continue.
Mr. Francois Daigle, who's the Associate Deputy Minister at the Department of Justice, Ms. Kathleen Roussel, who is the Director of Public Prosecutions and Deputy Attorney General of Canada, and George Dolhai, the Deputy Director of Public Prosecutions, both under the Office of the Director of Public Prosecutions. And we have our three existing members of the panel remaining with us. What we will do is we will finish the second round of questions. The Conservatives have advised they don't have any questions, so we're going to go to Mr. Rankin, and then I'll ask if anybody has any other questions they want to ask. Mr. Rankin, the floor is yours.
Thanks very much, Chair. And I just had two quick questions that I wanted to ask. The first involves legal aid and the funding thereof. In the estimates 2018-2019, they propose, quote, an increase of $3 million in contribution funding for the provinces and territories in criminal legal aid system and access to justice services. Now, there had been an earlier significant increase in legal aid funding, for which I commend the government, but I'd like to ask you what the views of the provinces and territories were about $3 million investment. There was an article I noticed in the Vancouver Sun by Ian Mulgrew that quotes the CEO of British Columbia's Legal Services Society, saying he was happy with the increase. In fact, it was a big one, but he said that it simply wasn't enough to do justice. Specifically on the immigration and refugee side, the estimates indicated an increase of $14.2 million for immigration and refugee legal aid, which I would have thought would be entirely federal. Maybe I'm wrong. But I wanted to know what the reaction of the provinces were in respect of that very separate increase to the legal aid budget. Our committee's been very seized of this, as you may know. We did a report, so I'd like your views on whether we are we've got to the right spot in terms of funding.
Monsieur le Président, je vais demander à Joanne Bernard.
Mr. Chair, I'm going to ask my colleague here to give you some clarification on the numbers, and then I'll respond to the narrative.
So in terms of legal aid for criminal purposes, criminal legal aid, you mentioned an increase of $3 million. This was part of an announcement of additional $88 million over 5 years in budget 2016. So the increase last year, the top up, if you allow me to use that term, was $12 million last year. It's $15 million this year. So it's an increase of 3, but it's really a $15 million top up, so quite a bit larger than perhaps what you had in mind.
Across the country?
Yes.
Yes.
Yes. And the other amounts you referred to was for
immigration
legal aid, so $14.2 million
yes.
announced in budget 2017, but there's also not yet reflected here an amount announced in budget 2018 for $12.8 million. So that will come. It's currently reflected in the budget implementation vote, and once the Treasury Board submission is approved, the funds will be transferred to us.
So that would mean a total of about $30 million, if I got that correct?
$27 million.
Yeah.
Yes.
And again, across, how is it allocated amongst the provinces? Is it done by, for example, if one province has a greater need than another, is it simply on a per capita basis?
So there is a formula, yes, and it's based on volumes of requests, also costs. The lawyers cost different amounts amongst the provinces. So it's formula based, and provinces approach us to get increased funding.
Is it the Government of Canada's view that, given it's a federal responsibility entirely, immigration and refugee matters, that should be 100% funded by the various legal aid programs across the country, or is there a cost sharing even for immigration and refugee legal aid?
There's a cost sharing amount, yes.
That seems to me to be inappropriate, just given that it's it's driven entirely by federal decisions, and yet the legal aid plans have to pick up a portion of that. But I guess that's a political decision, not a funding issue.
If I may add, we have different legal aid system across the country. So it depends the level of services that each country is ready to offer to their respective immigrants.
Right. May I have one more question on a totally different matter, if I may? And I concede at the outset this may not be an appropriate question within your bailiwick, although I did look at the departmental plan for the current year, and it talks about your responsibility in legislative services for particularly constitutional matters. And as you may know, the Supreme Court of Canada has frequently said that privacy is a quasi-constitutional right in this country. Dr. David Flaherty, who is probably Canada's leading expert on privacy and data protection, has written about our 35-year-old Privacy Act, claiming that the act is, quote, tantamount to a cart horse struggling to keep up with technologies approaching warp speed. Internet hadn't even been invented, let alone global positioning systems, biometrics, et cetera, et cetera. How can the government not take this on as a priority for legislative reform, given explicitly its quasi-constitutional nature?
I cannot answer for politicians for sure, but what I would like to say is, of course, at the department, we do study what other countries are doing to make sure that their private system evolves, taking into account digital rights, for example. So this is the work we are underdoing right now at the department.
So can I ask you explicitly, therefore, whether there is reform of the 35-year-old Privacy Act underway at this time?
What I can tell you is that, of course, we are taking into account all the evolution in terms of digital rights, as I said, and that, if there is any appetite, any time to bring a reform, we'll be prepared to propose and give recommendations to decision makers.
Okay, thank you.
Mr. Rankin. So basically, we've now finished our 2 rounds of questions. Is there any member that wishes to ask another question? Okay, Monsieur Picard.
Bienvenue, bonjour tout le monde. Welcome, everyone. We're going to change subjects. We're going to talk about fraud. In the last budget, there were some announcements made on reparations. I think it's a sort of a version of the American law. There seems to be some confusion, I believe, on how this was reported in the media. The project, the bill, removes sentences on enterprises or corporations. What are the challenges that led to that bill? Was it the Jordan decision was because of the delays in these commercial type of cases? Or was it a matter of trying to speed up the cooperation so that corporations and enterprises don't have a limbo status as delinquents or not? Well, thank you very much for your question, Mr. Picard. No, it wasn't an issue of the delays in the criminal system or the justice system, rather, that led to this initiative. Rather, to make corporations more accountable for their behavior and to try to prevent with a dissuasion effect. We can get compensation orders given the damages that the victims of these frauds suffered, and also to protect the innocent in these financial crimes, the employees, in other words, who were not really involved, and giving them court protection. Some of the agreements to be negotiated would have to be approved by the courts. This approach, this method, if you will, this procedure, is it aimed at corporations or enterprises that are doing business with the government, or is it generally the market at large? The market at large, if you will, the business world, and not only crimes against government. Thank you. Thank you, Mr. Picard. Any further questions? If not, I believe we have to vote on some of these measures. First, I would like to thank the witnesses everyone from the Department of Justice who appeared today. Thank you very much. Congratulations on the work you've been conducting. We all appreciate the work that you're doing in Canada, for Canada. Well, thank you very much, Mr. Chair, and thank you to the members of your committee. And we'll go forward. Okay.
I'm going to go now to just having our votes on the main estimates. Folks, first let me ask, is there unanimous consent that I group them all together instead of voting separately on 8 or 9 items? Or would you prefer that we vote separately? Is there consent to group? All right, so basically, the following are the votes. Vote 1 under Administrative Tribunal Support Service of Canada. Vote 1 under Canadian Human Rights Commission. Vote 1 under Courts Administrative Services. Vote 1 under Department of Justice. Vote 5 under Department of Justice. Vote 1 under the Office of the Commissioner for Federal Judicial Affairs. Vote 5 under the Office of Federal Commissioner for Federal Judicial. Oh, sorry. There's 2 votes under Federal Judicial Affairs, 1 and 5. Vote 1 under Office of the Director of Public Prosecutions, and 1 under the Registrar of the Supreme Court of Canada. And then finally a vote for me to report it back to the House less the amounts granted in interim supply. So those are all of the votes. All those in favor? And all those, so carried on division. All of them are carried on division. So thank you to the members. Yeah, that was, I lumped it as part of it to report back to the House. So thank you, folks, and meeting adjourned.